Slam dunk, are you ready to meet me? I'm here and I'm riding the fast lane. Don't let me down, I'm on fire. Does anyone else feel like a liar? It's all in your head and right. You just never use it.
Before moving to my argument, I remind the court of the important facts at bar. This is the case regarding 29-year-old Kyla Stark, Mr. Stark's wife and the mother of their 2-year-old child, who neglectfully succumbed to her death at West Valley Memorial Hospital under the care of Dr. Lenczner. According to the FLCCC Alliance COVID-19 Management Protocol, there has been a relentless malpractice of physicians deliberately withholding effective early COVID treatments and enforcing the use of toxic remdesivir in hospitalized patients, which may have unnecessarily killed up to 500,000 patients in the United States alone. Although there were significant improvements in Ms. Stark's condition when administered with ivermectin, Dr. Lenczner withheld administration of ivermectin not once, but twice while she was admitted at the hospital. And while Dr. Lenczner exhausted the hospital's treatment plan, which he is responsible for, he neglected to pursue the reasonable standard of care that was undoubtedly required to save her life. It was during the most critical last 6 days of Ms. Stark's life, Dr. Lenczner finally admitted defeat and approved of her transfer. But at this point, it was too late. Justices, the case at bar today is remarkably one of many cases that shows what results when we allow physicians to continue their abuse of power in the field of medicine, where the remnants of the archaic paternalistic policies and practices still used today blinds physicians towards the patient's best interest, setting an alarming precedent for the safety and autonomy of an individual who put their lives in the hands of doctors in Canada every single day. We, on behalf of the plaintiff, submit that this case exemplifies the need to testify that these negligent paternalistic practices should and need to be put to an end. Justices, today I will address you to the issue of standard of care. My co-counsel will address the issue of causation and vicarious liability. On the issue of standard of care, I have 3 points in my submission. In my first point, I will argue that Dr. Lenczner's failure to investigate the literature he was provided breaches Dr. Lenczner's requisite standard of care for failing to act with due diligence and a failure to uphold his duty to consult. In my second point, I will argue that Dr. Lenczner's refusal to treat Ms. Stark with MAC plus or ivermectin breaches Dr. Lenczner's standard of care for failing to uphold his duty to refer. And finally, my third point will argue that the hospital's standard of care to which Dr. Lenczner created was itself negligent. The requisite standard of care is one by which where a jury is to conduct parties in the case of medical negligence to consider whether the conduct of the case would have taken in the circumstances by a reasonable and prudent man. The court in Arlen versus Taylor also determined that the reasonableness of this conduct is determined by the standard adopted in the community by persons of ordinary intelligence and prudence. The court in Johnston versus Wellesley Hospital determined that when a medical practitioner declares himself as a specialist, a higher degree of skill is required and expected of him that of a practitioner who does not impose such a claim. Although a professional's conduct is deemed reasonable when following the standard practice of their peers, it is not determinative. In my first point, we submit that Dr. Lenczner's failure to investigate the literature he was provided breaches Dr. Lenczner's requisite standard of care for failing to act with due diligence and a failure to uphold his duty to consult. In the case of McSween versus Lewis, the court held that it was the physician's responsibility to act with due diligence in acquiring facts as to be fully informed of the material facts upon which a negligence claims can be based. This includes acting in due diligence in requesting and receiving medical opinion, where in some circumstances, an external medical opinion is necessary for a physician to determine the next course of action. The court in Norris versus LeBlanc asserts that the standard that is encompassed in a duty to consult. And the court in Scott versus Moen, the duty to consult is indicated when it satisfies any of the 4 requirements. The doctor is unable to diagnose the patient's condition, the patient is not responding to the treatment given, the patient needs treatment which the doctor is not competent to give, and the doctor has a duty to guard against his own experience. It is then clear that Dr. Lutzier failed to act with due diligence in regards to his duty to consult with Dr. Strange, as the second requirement is applicable. Ms. Stark was not responding to the treatment that was being given. When given a parallel scenario to the facts at bar, Dr. Lutzier claimed in his discovery that in the case where a patient's condition is deteriorating and the physician has exhausted all treatments, and a colleague of respected in their field sends the physician literature regarding a life-saving treatment that could aid the patient, his duty as a medical specialist would be to, quote, engage in a formal discussion with his colleague and read what they had sent him. Although the facts at bar are parallel to that of this hypothetical scenario that Dr. Lutzier answered, he neglected in his own terms his duty to consult Dr. Strange and read the literature that was sent to him. In the case of Waters versus Hwang, the court determined that the physician fell below the standard of care of a reasonable emergency physician to look at any of the patient's prior medical history or results, despite it being readily available to him. This was the evidence that the physician's biased conduct contributed to him avoiding reasonably necessary tasks required of a reasonable emergency physician. It is evident that Dr. Lutzier also failed in this regard. In his disposition, Dr. Lutzier was unaware of Ms. Stark's treatment history, in that he was unaware that Dr. Papadopoulos actually administered the hospital's protocol. Later in his disposition, he also used Ms. Stark's vaccination status as a reason why her condition was not improving, despite her being double vaccinated. It is unreasonable to assume that when the existing standard of treatment is allowing a patient to die without consulting their medical records or investigating reasonable and available alternatives constitutes a neglectful conduct. Dr. Lutzier not only had access to consult with Dr. Strange, an equally experienced physician, Dr. Strange, following her email and phone calls, which remained unanswered, physically came to him in efforts to consult. The refusal to accept this easy means of communications shows that Dr. Lutzier failed to uphold both his due diligence and the duty to consult under the standard of care that he was bound to. Proceeding to my second point, I will argue that Dr. Lutzier's refusal to treat Ms. Stark with Math Plus or ivermectin breaches Dr. Lutzier's standard of care for failing to uphold his duty to refer. The issue that arises is, why did he only agree to transfer Ms. Stark on October 19th, a critical 6 days after he had exhausted all his options? The court held in Scott versus Moen that the most critical factor in the duty to refer is timing. In Gillis State versus Marriott, the defendant was found to be negligent in failing to refer the patient in a timely fashion. The court held that the defendant ought to have sought a referral in cases where the course of treatment selected by the defendant worsened the condition of the patient.
Counsel, sorry, can I interrupt just for a moment? And I
Yes,
apologize
Justice.
for doing that. I want to go back to the literature issue.
Yes.
And I understand your position is Dr. Lutzier asked for the literature to be sent. It was sent. It was negligent not to review what was sent to him, presuming, of course, he had the time and the ability to do it as a busy doctor. But what flows from that? So he didn't read the literature. Is there some suggestion that if he read the literature, he would change his path of treatment?
Thank you for your question, Justice. The question isn't necessarily what would have happened if he read the literature. The question is if he did pursue the literature at all. A reasonable and prudent physician in his position, when he has exhausted all his treatment, would have been to pursue his duty to consult and his duty to review literature. And it does not matter that he didn't read the literature that was specifically sent to him by Dr. Strange. It is the fact that he neglected to pursue any literature at all. And it is also the case that Dr. Lutzier himself is responsible for the COVID treatment that is prescribed by the hospital. And under that duty, he has the duty monthly to review literature as to ensure that the hospital protocol is up to date. But he fails to do it in this regard, as during the time Ms. Stark was under Dr. Lutzier's treatment, the literature regarding ivermectin and Math Plus protocol was available in the agencies that Dr. Lutzier himself claims that he and his team relies on in order to make the COVID treatment protocol. For instance, Dr. Lutzier says that he relies on the FDA. But our secondary source in our factum shows that the MAP protocol was FDA approved before and during the time that Dr. L was treating Ms. Stark. If I may proceed with my argument, we submit that Dr. Lutzier is negligent for comparable reasons as to Scott versus Moen and Jill Estate versus Marriott. It's incomprehensible that a deferral was not arranged in timely fashion, especially considering how from the administration of remdesivir on the 13th, Dr. Lutzier made no further efforts in finding alternative treatments for Ms. Stark. The court in Norris versus LeBlanc upheld a modified locality principle and held that despite a doctor being measured by the standards outlined in their communities, if the doctor is able to easily access major medical centers, they will utilize those centers when necessary. In the 6 days where Dr. Lutzier was in clear admittance that he had exhausted all the relevant treatment, not only was this not the case, he was clearly aware that the referral to Dr. Strange was an accessible and the determinative course of action. Despite this being the last course of action, Dr. Lutzier chose to admit her under Dr. Strange's care on the 6th day of her last treatment received by him, a mere hour before her death.
Counsel, can I interrupt for a second?
Yes.
Now, if I understand it, what the plaintiff is suggesting is a transfer to something called Fairview Health from the West Valley Memorial Hospital should have occurred. Is that correct?
That's correct.
Can you tell me, is Fairview Health a hospital?
Yes, that is the hospital.
And do you know, is there any evidence as to whether there's a difference in the level or facility between West Valley Memorial Hospital and Fairview Health Hospital?
In the FactSat bar, what the more than the hospital itself, what was specified is the level of specialization of the two physicians that are being addressed, Dr. Lutzier and Dr. Strange. It is established that where Dr. Lutzier is chief of the hospital and a CFPC specialist, Dr. Strange similarly is also a specialist in the ICU and a specialist regarding COVID treatments, and she has assumed thousands of patients under the care who has been in similar situations as Ms. Stark. And so it can be easily determined that regardless of the hospital, the focus is that Dr. Strange was a competent physician who could have easily assumed care of Ms. Stark, as she has treated patients in similar conditions to Ms. Stark.
Just one follow-up then. So just so I'm clear on what you're saying, you're essentially saying that the only difference between West Valley Memorial Hospital and Fairview Health Hospital is that the patient would have seen Dr. Strange as opposed to Dr. Lutzier. Is that correct? Is there any other difference?
There is a large difference that I am going to address in my third argument, which I will proceed, which is that Dr. Lutzier is responsible for the hospital standard of care. And for this reason, the standard of care itself is completely different to that of how Dr. Strange would have consulted Ms. Stark. For instance, the hospital's COVID treatment under Dr. Lutzier is to administer remdesivir and to use a ventilator. And the last stage, stage 9, is to increase the ventilator. And that was the final course of treatment. Whereas for Dr. Strange, she would suggest to administer ivermectin per dose for 5 days, administer vitamin D on day 1, and for the next 7 days, monitor vitals every day. And when a patient's condition is so severe that they reach the ICU, which would have been the condition that Ms. Stark would have been in on October 13th, she would administer Math Plus, which includes ivermectin and vitamin D. So the standards of care that would be prescribed by both hospitals is very, very different. I will proceed with my third point to argue that the hospital standard of care to which was Dr. Lutzier created was itself negligent. Dr. Lutzier's administrative positions places him at a greater proximity and leverage to his responsibilities to uphold both the administration and creation of the standard of care at the hospital. On one issue that arises from his power is his ability to have controlled what literature is deemed satisfactory without need of influence from his team. Per his employment agreement, Dr. Lutzier is the primary developer of West Valley Memorial Hospital's COVID-19 guidelines, which stands as the standard of care for the treatment of COVID-19 administered at the hospital. Firstly, what constitutes high quality studies? According to Dr. Lutzier and his discovery, they must all be relevant literature comprising of peer-reviewed publication and meta-analysis. Dr. Lutzier also wrongfully claimed that he skimmed the literature that was sent to him by Dr. Strange, where he excused his dismissal of upholding to consult her literature, accounting to Dr. Strange's supposed bias, where she sent him literature that was, quote, only relevant to her perspective. This is factually incorrect, Justices. And according to Dr. Moriarty, who shares Dr. Lutzier's opinion of supposed dangers of ivermectin, claims that 5 randomized control studies is the gold standard for looking at the efficacy of ivermectin. Dr. Strange forwarded Dr. Lutzier a meta-analysis of ivermectin and an FLCCC review of ivermectin, including 64 trials. This also included not 5, but 30 RTCs. How is it possible that his entire team was unaware of this fact? In his disposition, Dr. Lutzier claimed that despite his conjecture that his team is responsible for West Valley Memorial Hospital's COVID-19 treatment guidelines, in which a team of experts discuss what a high quality literature is to be applied in their guidelines, there's evidence that raises suspicions on this claim. In paragraph 443, where Dr. Lutzier inquired about who is responsible for determining a quality of study to satisfy this high quality requirement, he states that it is him who is able to make that determination. Dr. Lutzier makes no reference to a reliance on his team to make this judgment. If Dr. Lutzier and his team is held accountable for reviewing all relevant literature, how is it that it is Dr. Lutzier himself who determines what is a high quality study? We inquire if this completely dissolves the purpose of having a team to compile and review necessary research. And more so, we raise to the court evidence that Dr. Lutzier was in a position where these biases could not be checked by his team of experts, regardless of their existence. In summary, Dr. Lutzier breached the requisite standard of care for medical negligence by failing to act with due diligence and a duty to consult when he failed to investigate the literature that he was provided with. Second, for failing to abide by the duty to refer when he denied Ms. Stark treatment with MAT plus and ivermectin. And thirdly, Dr. Lutzier is responsible for the standard of care prescribed at the hospital, and the standard of care itself is negligent due to the biases that were left unchecked as a result of his position that allowed him to proceed in such leniency. Unless I may be of some further assistance to the court, this concluded my submissions. My co-counsel will continue our argument of causation and vicarious liability. Thank you, Justices.
Good afternoon, Justices. My name is Tanya Sleman, and I will be presenting the second and third issues of causation and vicarious liability. On the issue of causation, I plan on showing that Dr. Lutzier caused the harm that was sustained by Ms. Stark. I have 2 points on my submission. The first establishes that using the but-for test, the injury to the plaintiff would not have occurred but for the negligent conduct of Dr. Lutzier. The second establishes that causation need not be determined by scientific precision or experts, as sufficient evidence exists within the case to constitute an inference of causation. Thus, causation is a practical question of fact that should be determined by ordinary common sense. On the issue of vicarious liability, I will be arguing that West Valley Memorial Hospital should be held vicariously liable for the negligent actions of Dr. Lutzier. I have 2 points on my submission. The first illustrating that Dr. Lutzier and the hospital had a direct employer-employee relationship, as he was not only a physician at the hospital, but also the chief of the hospital and medical director of the emergency department at the time that he was treating Ms. Stark. My second point highlights that the negligent actions in question occurred during the scope of his employment at the hospital. Moving on to the arguments for the second issue of causality, it can be said that causation is determined by a balance of probabilities where the plaintiff establishes that the defendant caused or contributed to the injury. As established in Snell versus Farrell, the test used to determine causation is the but-for test, which states that the injury to the plaintiff would not have occurred but for the negligent conduct of the defendant. Dr. Lutzier knew or ought to have known that the supportive treatment he was providing to Ms. Stark, especially in the last 6 days at the hospital, were ineffective. He was negligent in disregarding Ms. Stark's vaccination record and medical history. He ought to have consulted Ms. Stark's medical records, in which it would have been evident that remdesivir had not worked on Ms. Stark and that he had exhausted all other treatment options except for MAT plus and ivermectin. Furthermore, his lack of collaboration with and refusal to refer to materials sent by Dr. Strange make it highly probable that the harm that befell Ms. Stark would not have occurred but for Dr. Lutzier's negligent actions. His lack of referral meant that he did not resort to any remaining treatment options and thus did not administer math plus protocol and ivermectin when he should have. Dr. Lutzier adhered to the standard of care and performed the Had Dr. Lutzier adhered to the standard of care and performed the due diligence expected of a physician in his position, it is reasonable to assume that absent his own biases against ivermectin use, Dr. Strange's documents and Dr. Strange herself would have encouraged Dr. Lutzier to administer math plus protocol and ivermectin. Dr. Lutzier's lack of adherence to his duty to refer during the last 6 days of Ms. Stark's life ultimately led to her demise, especially as other physicians, such as Dr. Strange, have been able to nurse individuals in the same conditions as Ms. Stark, namely on a ventilator with low chances of survival, back to health after administering math plus and ivermectin during the same stage of illness. Finally, given the circumstances of COVID-19 and the lack of hospital visitation at the time, Ms. Stark's stay, Dr. Lutzier's duty to consult with the family was heightened and also neglected. If not for Dr. Lutzier's actions and his lack of adherence to the proper standard of care, Ms. Stark would likely not have succumbed to her illness. As seen in the case of Athey versus Leonati, causation need not be defined by scientific precision. Under certain circumstances in which evidence is sufficient to constitute an inference of causation, there is no need for scientific proof. The defendant's negligence need not be the sole cause of injury. Rather, causation would be a practical question of fact determining using ordinary common sense. So long as it can be shown that the defendant's conduct caused part of the injury, the defendant is liable for injury. As stated above, the actions performed by the defendant need not be examined with scientific precision, as they alone are enough to have ordinary common sense to determine causation. On a balance of probabilities, without the need for scientific precision, Dr. Lutzier's negligence was a breach of reasonable standard of care and the cause of Ms. Stark's declining health condition, if not her death. To establish vicarious liability,
Sorry, counsel, and I apologize for interrupting again. So the theory on the but-for analysis is but for Dr. Lutzier's negligence, Ms. Stark would have received ivermectin. That's the first step. Next step would be that the ivermectin would have, in essence, prevented her death. Now, I agree with that, with Snell and Farrell, that you take a common sense, pragmatic approach, but there has to be something there. There has to be some facts that we can point to that allows the court to reach the inference that, in fact, with that path of treatment with the ivermectin, she would still be alive today. So what facts do we have that we can use to support that conclusion?
the two facts can be found in the disposition of Dr. Strange, because she had several thousands of patients who were in the exact same state of Miss Stark when she started treating them, and she provided them with the Math Plus protocol and the ivermectin as a supplement to the Math Plus protocol, and they happened to continue living and surviving. And in addition to that, there are several meta studies showing the effectiveness of Math Plus protocol and ivermectin, and how effective they can be on end stage patients such as Ms. Stark. I hope that answers your question, Justice. To continue, to establish that West Valley Memorial Hospital is vicariously liable for the negligent acts of Dr. Litzier, it must first establish that the acts committed were negligent and that he had an employee-employer relationship with the hospital at the time that he was treating Ms. Stark, and that he had committed the negligent act while under employment of the West Valley Memorial Hospital. As established by my co-counsel and I, Dr. Litzier acted negligently when he breached his standard of care, which resulted in him causing the harm that befell Ms. Stark. In turn, employee relationship with the hospital and when the negligent act was committed are now being examined. Given that Dr. Lenczner signed a contract with the hospital on February 11, 2016, which appointed him as chief of West Valley Memorial Hospital and its medical director of the emergency department, it can be said that he was not only working within the hospital in the capacity of a physician, but also directly as an administrative role within the hospital. As administrative roles fall under the Ontario Hospitals Act rather than the Medicines Act, the preventing negligence in that field would be the responsibility of the hospital as well as the physician. Thus, West Valley Memorial Hospital is vicariously liable for the acts of Dr. Lenczner. This is furthered by the fact that he was employed at the hospital at the time of negligence when he was treating Ms. Stark. To conclude,
Can I, counsel, sorry to interrupt. I just have a question. You say he had an employee relationship with the hospital. Is that with respect, like he had three roles, as I understand it. He was an administrator, he was the chief of a department, and he was also a practicing physician in the hospital, correct?
correct.
And do we have an employee-employer relationship for all three of those roles?
For two of the roles, we have an employee-employee relationship in that he was the head of the hospital and he was the director of the emergency department. In his role as a physician, he would fall under the under the Ontario government. However, it can arguably be said that within all three roles, he would fall under the hospital's employment purely because he is the one that's creating the protocol that all physicians in the hospital are using to treat COVID-19. So while technically only two of the roles fall under the hospital employee-employer relationship, arguably all three of them are very much intertwined.
So can I just ask for one clarification? And are you arguing then that the vicarious liability is around the creation of the guideline and that because he was part of an administrator creating the guideline, that's where the vicarious liability hits? Or are you also suggesting that vicarious liability flows from the actual treatment that the physician gave?
I'm suggesting both, Justice.
Thank you.
Thank you. Now to conclude, Dr. Lenczner breached his standard of care, caused harm that was sustained by Ms. Stark, and thus West Valley Memorial Hospital was vicariously liable for Dr. Lenczner's actions as the negligence occurred while he was employed by the hospital. The court should consider the life that Ms. Stark lost, and more importantly, the countless other patients that Dr. Lenczner will treat in the future who may encounter the same negligent actions unwittingly. At this time, we seek damages, costs, and such further and other relief as this honorable court deems just, and an order for the College of Physicians and Surgeons of Ontario to further investigate Dr. Lenczner's conduct under the Medicine Act. Unless I may be of further assistance to the court, these are my submissions. Thank you.
Ms. Sleman, I had a question for you. I'm going to take you to paragraph 37 of your factum. So at paragraph 37, about halfway down at the bottom of page 17, we have a sentence that says, had he not been willfully blind in adhering to the standard of care of due diligence expected of a physician in his position, it's reasonable to assume that Dr. Lenczner would have dispelled his biased knowledge and considered the possible efficacy of ivermectin after consulting with Dr. Strange's sent documents, and it carries on. Is it your position that a treating physician must consider all treatments which have possible efficacy against a particular condition?
It is our position that they should consider it under their standard of under the standard of care, because standard of care states that all standard of care has the standard to refer under it. So he must refer to all eligible materials that could be of assistance. And then once he has gone through all treatments that are available to him, he should apply the last course of treatment, which in this case would be ivermectin and MAF+. I hope that answers your question, Justice.
Thank you.
The court now invites counsel for the defendant to begin.
Thank you. Good afternoon, justices. I'd like to thank the plaintiff counsel for their submission and this court for their time today. My name is Bola, and along with my co-counsel, Sarah Torelli, we are here today on behalf of the defendant, Dr. Justin Luthier. The tragedy that's led us here today is one that has been felt by far too many families throughout this unprecedented time. There have been upwards of 5 million deaths across the globe since the start of COVID-19. Many that share a similar medical history to that of Miss Kyla Stark, young, healthy, and vaccinated. COVID-19 sees no age or medical history. It has no compassion or sympathy for its victims. Instead, when medical professionals from across the world come together to create protection against it, it mutates, shifts properties, and moves like a chameleon throughout our society. Our medical professionals have stepped up to the plate, old and young, those who are long retired, and those who are just starting their careers. They've come together to strategize, collaborate, and do what it takes to combat this deadly virus. Dr. Luthier, Dr. Strange, medical experts, Dr. Moriarty and Dr. Titchener, no matter their professional opinions, are all heroes, fighting every day to do the best that they can. At the conclusion of our submission, this court will clearly see that the tragic loss of Miss Kyla Stark is the result of her contracting a deadly and ever-evolving virus, leading to the development of fibrotic lung disease, which ultimately led to her death, not as a result of the conduct of the defendant, Dr. Justin Luthier. My colleague and I will address 3 main points to the court today. I will address the issue of standard of care, while my colleague will address the issues of causation and vicarious liability. My submission will consist of 2 key points. First, that the standard of care in this case is that of a reasonable and diligent physician, nothing more and nothing less. And second, that Dr. Luthier complied with his duties and principles of a competent medical professional and aligned himself with the professional code of ethics. The standard of care in this case is that of a reasonable and diligent physician, nothing more and nothing less. To succeed on a claim for medical negligence, the following 4 elements must be met. The doctor owed the plaintiff a duty of care, that doctor breached the applicable care established by law, the plaintiff suffered an injury, and that the doctor's conduct was the actual and legal cause of that injury. The onus rests on the plaintiff to prove these factors. If the plaintiff fails to prove one of the elements, then the onus is not met and the action must be dismissed. In our submission, we will show that the plaintiff has failed to advance sufficient evidence in fact and in law to hold Dr. Luthier negligent. It is not in dispute that Dr. Luthier owed Ms. Stark a duty of care upon the formation of a doctor-patient relationship. And it is not in dispute that there has been a tragic loss here. However, in law and in fact, Dr. Luthier did not breach the standard of care required of him, and his conduct was not the cause of the loss suffered by the plaintiff. The standard of care for medical professionals in Canada has long been established as that of what is accepted of a normal and prudent practitioner of the same experience and standing. Dr. Luthier holds himself out to be a specialist and therefore is required to display the standard of proficiency of an average specialist in his field. The test is not if something better or different could have or should have been done, but if the doctor ultimately failed to meet the standard of the profession. The Supreme Court of Canada in Wilson v. Swanson sets out the test of reasonable care by stating that the test can be no more than whether the decision made was a result of the exercise of intelligence professed, or if what was done, such that disregarding it may be the exceptional case. But in all circumstances, if a substantial opinion confirms the decision, then there is no breach. It is the position of the defendant that Dr. Luthier's choice to administer supportive care was not only the standard of care at that time, but that his decision regarding this course of treatment was based on informed intelligence and scientific knowledge and widely accepted by the medical community at large. Addressing my second point, that Dr. Luthier complied with his duties and principles of a competent medical professional. In medical negligence cases involving parties with special skill or knowledge, expert opinion evidence is necessary to educate and allow the court to draw inferences from the facts. Expert evidence is required in cases where the standard of care of causation are not ordinary matters of common sense. The accepted standard of care in this case, outlined by both expert witnesses, indicate that the accepted standard was that of a reasonable, diligent, and prudent practitioner, each stating by some variation that Dr. Luthier had met this standard. Dr. Strange states that the requisite standard of care was not met by Dr. Luthier based on his failure to administer ivermectin and Math Plus, and his failure to read the literature forwarded to him. She further elaborates that the expected standard in this case includes due diligence, where she states that either the review of the material sent to him or conducting his own investigation to then make an educated and evidence-based decision would amount to due diligence. Dr. Lutsier did in fact make an educated and evidence-based decision when making the reasonable choice to administer the approved hospital COVID-19's protocol. Dr. Lutsier's medical and professional opinion differed from that of Dr. Strange, and in itself is not a negligent act nor breach of the standard of care. Dr. Lutsier's opinion is that the literature that Dr. Strange relied her medical opinion on did not come from a reliable and trusted source. Dr. Lutsier and his research team updated the COVID-19 protocols on September 20th, 2021, as they have done each month since its development. It is reasonable to conclude that any and all information available to the medical community regarding treatments for COVID-19 as of that date were digested and vetted by the larger and trusted agencies and the hospital's research team. Dr. Moriarty reiterated that the requisite standard of care is the administration of supportive care and had been for over a year at the time of questioning. Though Dr. Moriarty also states that she would have read the study sent by Dr. Strange, she reiterated that she thought it would be strange not to investigate unless the physician already knew about those studies or had the solid evidence to refute them. In this case, the defendant submits that Dr. Lutsier already had a solid evidence base and previous knowledge about ivermectin and math protocols. Dr. Lutsier's refusal to read the specific studies contained within the email does not amount to the fact that he did not have the knowledge contained therein. In order to find a breach predicated on that fact, it would need to be found that there was no other platform that Dr. Lutsier could have been informed of like information, and in fact did not possess the knowledge or familiarity of that research as a whole. Dr. Lutsier complied with his duties and professional code of conduct by doing his due diligence and making an informed, reasonable choice in the course of treating Miss Stark. He spoke with Dr. Strange, heard her medical opinion, and gave her the space to have a conversation about a different course of treatment, and fulfilled his duty to consult within the profession.
Counsel, can I interrupt again? And again, I apologize. And maybe you're coming to this, and probably are, but the plaintiff's counsel has indicated that in Canada, there is a duty to refer in some situations. And as I understand the factual framework here is that the plaintiff wanted ivermectin. That was her desire to have that. I understand that there were other physicians, Dr. Strange, for example, equally qualified medical doctor who supported the use of ivermectin. And I guess I would appreciate your comments on the concept of the duty to refer in this context, and specifically in relation to what say a plaintiff should have in their own medical treatment.
So it's our position that there was no duty to refer when Dr. Lutsier was capable of treating Ms. Stark, and that the treatment, the duty to refer has been found to provide treatment to a patient the doctor is incompetent to give typically. So if Dr. Lutsier felt as if he could no longer care for Ms. Stark, at that point, it would have been his obligation to transfer or to refer the patient. And pardon me, are you able to please repeat the last part of your question?
Certainly. So I guess what I was wondering is, in this context, how do the plaintiff's wishes on how they want to be treated and receive medical care, how does that fit into this scenario?
So, pardon me while I just gather my thoughts for a moment. When it comes to patient autonomy, it's the duty of the doctor to speak with the patient about the treatment options that are available and to ensure that they are on the same page. Dr. Lutsier explicitly informed Ms. Stark and Mr. Stark of the unwillingness to administer math and ivermectin and disclosed the treatment plan that would be offered at the hospital. He reasonably relied on his team and the previous doctor who assumed care initially who started supportive care treatment as a common practice to verbally disclose kind of the benefits and risks of the treatment. And so at that point, you know, it would have been the patient to remove themselves under the care of the doctor if they didn't agree with that treatment plan.
And ultimately, there was a referral, just a little too late, perhaps.
Correct, yes. Okay, pardon me. And so just circling back, Dr. Lutsier believed that had he in fact followed the advice of Dr. Strange, possessing the knowledge he had about the treatment plan she suggested, that he would have breached his ethical duty to Ms. Stark to provide the best care that he could and not inflict harm or injury on her. He could not in good conscience administer a treatment to a patient that he does not believe to be a reliable and trusted course, backed by the agencies and regulatory bodies of the profession in the circumstance. In order to support the finding of a breach of the standard of care required, a physician must be guilty of such a failure that no other physician with ordinary skill acting with ordinary care would be guilty of in like circumstances. Having a difference of opinion in another similarly trained specialist regarding a diagnosis or course of treatment is not enough to amount to negligence. In an unprecedented time, hospitals, physicians, and other medical professionals work under increasing amounts of stress and pressure to act within the confines of their code of ethics and professional responsibility. Dr. Lutsier acted in a manner consistent with his professional duty and standard of care by following the very protocols put in place to treat patients with COVID-19. In Ternutson v. Korn, the court stated that the conduct of physicians must be judged in light of the knowledge that ought to have been reasonably possessed at the time of the alleged act of negligence. Dr. Lutsier's medical opinion was reasonable in light of the circumstances. He relied on research team and trusted regulatory bodies to thoroughly vet the ongoing studies produced with respect to the different COVID-19 treatments. To date, ivermectin and Math Plus protocol is not accepted by the larger medical community, and advisories against the treatment are suggested. Dr. Lutsier administered supportive care to Ms. Stark and many other patients under his care. He followed a practice in the profession that was well established in light of the current circumstances and widely accepted. For the reasons I have submitted, it's clear that Dr. Lutsier did not breach the standard of care required by him. My colleague will now go on to address the issues of causation and vicarious liabilities. I will respectfully close my submission. Thank you.
Counsel, before you pass it on, one more follow-up question to you. Ultimately, as a physician, as a doctor, your goal is to save lives, and that is the ultimate goal. I understand that hospitals have protocols, and Dr. Lutsier, the multiple roles and hats that he was wearing, had to look after different aspects. But could you please comment on what is the fact? What is your thoughts on the fact that the patient responded to ivermectin in a way that the patient didn't respond to any other treatment? At that point, should a doctor, realizing that the goal is just to save the life, put aside some of the other factors and just do what's best in terms of what that patient is responding to?
Yeah, no, that's a very great point and a great question. And my co-counsel will get into that a little bit more in her submission. But just to give you kind of a brief, our position on that is the fact that there is no actual evidence that the administration of ivermectin was in fact the cause of her improvement. Supportive care treatment had been started, I believe, a day or two beforehand, in which case, when she was admitted to the ICU, dexamethasone was given. And dexamethasone is an anti-inflammatory used to target the inflammation within the body. And so I guess circling back, what I'm saying is there is no proof or evidence to support that ivermectin itself was the sole cause of her interim recovery.
Thank you, counsel, and thank you, your honors, for being here today. I will be addressing issues 2 and 3 for you here today. Issue 2 is that of causation, and issue 3 is that of vicarious liability in relation to West Valley Memorial Hospital. I will deal with the issue of causation fully before turning your attention to vicarious liability. As outlined by Madam Moderator, the question to be answered in the issue of causation is, did Dr. Lutzier's conduct cause or contribute to the harm or injury sustained by Ms. Stark? There are two elements of causation that need to be considered in order to answer that question. The first element is whether the defendant's breach of the standard of care was the actual cause of the injury suffered. And the second element is whether that outcome was reasonably foreseeable to the defendant. To address the issue of causation, I will be making three key submissions. First, I will argue that the plaintiff has failed to adduce evidence to support a causal or contributory link between Dr. Lutzier's conduct and Ms. Stark's death. Secondly, I will demonstrate that causes independent of Dr. Lutzier are a more likely cause of Ms. Stark's death. And finally, I will argue that the death of Ms. Stark was not reasonably foreseeable in the mind of Dr. Lutzier. At the culmination of my submissions, this honorable court will be able to see that this tragic death of Ms. Stark was in fact due to complications arising from COVID-19, and those complications were not the result of Dr. Lutzier's decision to withhold or discontinue Math Plus or ivermectin alone. I turn now to our first point, which is that there is no evidence to conclude a causal or contributory link between Dr. Lutzier's conduct and Ms. Stark's death. The plaintiff must be able to demonstrate that but for the action or inaction of Dr. Lutzier, Ms. Stark would not have died. There is no medical evidence before this court showing that withholding or discontinuing Math Plus or ivermectin alone would in itself cause any harm, and certainly not to the degree that Ms. Stark suffered. I am mindful that according to the Supreme Court in Snell v. Farrell, the court must approach this analysis with a robust and pragmatic view to the facts as a matter of fairness. This means that inferences can be drawn where it is reasonable to do so. However, in the complete absence of evidence to support this causal or contributory link, we submit that by relying solely on a robust and pragmatic analysis, which is what would be necessary here, the court would be undertaking speculative reasoning, which is cautioned against in the 2016 Supreme Court of Canada case, British Columbia v. Fraser Health Authority by the dissenting opinion. There are two bases upon which this court could potentially draw inferences, and it is our submission that reliance on either one of those would be unreasonable and would amount to speculative reasoning. The first basis of evidence that could support drawing an inference between Dr. Lutzier's actions and Ms. Stark's death is the temporality between the two. However, as said in Barber v. Wilson, it is not enough on its own to prove a causal link. This type of connection cannot be relied upon as proof of causation. It is merely a hypothesis. It has not been tested or deduced through medical evidence. And I would submit that given the fact that there were so many other variables and factors in relation to Ms. Stark's ongoing treatment, that it would be even more inappropriate to rely solely on this factor. The second basis of evidence that could support drawing an inference between Dr. Lutzier's actions and Ms. Stark's death is the generalized statements adduced by the plaintiff surrounding the alleged effectiveness of Math Plus and ivermectin. I will not reiterate the points my co-counsel has made in relation to the unreliability of this evidence, in which the plaintiff doctors are relying on, but I would like to remind the court that this is relevant here as well. Notwithstanding those evidentiary issues, the plaintiff has not shown that these studies would have been relevant to Ms. Stark at this specific time. There is no evidence to suggest that the alleged effectiveness would have even been the same in the case of Ms. Stark because of the other treatment she was currently undergoing. Dr. Strange was not the doctor of record. Sorry, go ahead, Justice.
And again, I apologize for interrupting, but I want to follow up on something that Justice Dhaliwal raised, and that is on two occasions when she received the drug that she thought she should be on, she improved, and she improved significantly. And on those occasions when the other treatment was being provided, she deteriorated. And I'm wondering why that's not enough on a common sense and pragmatic approach to allow me to draw the inference that if she was placed on ivermectin for a third time, that her condition would have improved and she'd be alive today.
That's a great question, Justice. Sorry, just one moment. To that point, sorry, actually, can you just repeat the last part of your question there?
So the question I had is, why can I not draw an inference that if she was placed on ivermectin for a third time, that she may well be alive today? And Part of that may be based on individual variation to different types of treatments, and some people do well with some people do well with other. But we seem to have a bit of a track record on how she does when she's placed on the ivermectin.
Yes. So to that point, it is our submission that COVID-19 has devastating effects on the body. It causes a wide range of symptoms and has devastating effects. It is our submission that a medication that is administered within hours would not be sufficient to provide the bounce back that Ms. Stark had realized. It is our submission that it's more likely that a prolonged course of treatment would have allowed Ms. Stark to recuperate. I hope that answers your question.
Yes, thank you.
Okay, so in sum, the plaintiff has failed to establish a causal link between the conduct of Dr. Lutze and the death of Ms. Stark. As such, they haven't met the threshold of proving on a balance of probabilities that Ms. Stark's death was caused but for the defendant's action. The Supreme Court of Canada and Resurfice reminds us that it is critical this burden be met, so defendants are not held liable for injuries that are linked to causes independent of themselves or anyone else. Which brings me to my second submission. A reasonable inference can be made that the interjection of alternative treatments by Dr. Strange to Dr. Lutze's patient was detrimental to Ms. Stark. Dr. Lutze was administering the supportive care protocol to Ms. Stark, and as my co-counsel has mentioned, this is the standard of care, no more and no less. As indicated by Dr. Lutze in his sworn deposition, it is the widely accepted evidence-based standard of care amongst hospitals that deal with COVID-19 patients. This particular treatment protocol was meticulously researched and developed by a team of experts from across the medical field to be the most effective in light of the circumstances. Given the healthy disposition of Ms. Stark, had this course of treatment been rendered fully from the beginning, as it was supposed to have been, it is more likely she would have had a better chance of fighting off the COVID-19 virus that eventually caused her death. Ms. Stark ultimately died of fibrotic lung disease, which is precisely what is being targeted by the supportive care protocol administered by Dr. Lutze. Therefore, it is likely that constant interruptions to Dr. Lutze's course of treatment could have contributed to the development of fibrotic lung disease. Plaintiffs suggest withholding of ivermectin caused Ms. Stark's death, and in order for that to be true, the plaintiff would have to show that ivermectin would have in fact saved her life. They would need to adduce positive evidence, so it would be improper to infer causation without that positive evidence. To conclude this point, the court cannot be certain which one of these medical interventions actually caused the deterioration or death of Ms. Stark. A reasonable inference can be drawn that Ms. Stark would have benefited more from the administration of one constant protocol, which was congruent with the standard of care, and that did not happen here as a result of forces outside of Dr. Lutze's control. I will now turn to my final point concerning causation, which is that of remoteness. The court in Mustafa v. Culligan of Canada concluded that in order to find negligence, the common law requires the damages to be foreseeable to a reasonable person in the defendant's position. This case also held that the degree of probability of a specific damage is not so high that a mere possibility of damages arising would be sufficient. Even plaintiff's witness, Dr. Strange, agrees medical decisions should be evidence-based. The evidence-based Dr. Lutze was drawing from when he made his decision to remove and withhold these unsupported protocols was just that. He was operating in accordance with what the evidence supported. Standard care was effective, and math plus or ivermectin alone was not proven effective. It is illogical that Dr. Lutze would have had reasonably foreseen the consequences of his actions to be detrimental to this patient. And further, given that the proposed treatment had not been proven to be effective, we would submit that it's illogical that another physician in Dr. Lutze's position would have also believed that stopping an unsupported treatment in favor of a supported treatment would be harmful. There's nothing to suggest that Ms. Stark was presenting as a patient without ordinary fortitude that would make the supportive care protocol inadequate for her. In summary, Your Honors, we submit the plaintiff has failed to prove on a balance of probabilities that but for the actions of Dr. Lutze, Ms. Stark would not have died. We know Ms. Stark's tragic death was caused by complications arising from COVID-19, her death. That would amount, in my submission, to speculative reasoning. If you're trying to anticipate any sort of cause, the fact of the matter is there are many potential causes. none of which would have been in our defendant's cause or control. I hope that answers your question.
Right, but does the plaintiff have to disprove your position? And I take it your position is that the cause of death was not negligence. The cause of death was something else that was outside of the control of your physician. But is it up to the plaintiff to disprove your theory, or is it up to the plaintiff to simply prove theirs?
I would suggest it's simply up to in this case, for the plaintiff to prove their position, and they have failed to do so.
They have once.
Thank you.
The court now invites counsel for the plaintiff to begin their 3-minute optional rebuttal.
Thank you. We would like to start off with actually the question that was raised by Justice Watson. We raise in our factum that as long as it can be proven that the defendant's conduct was part of the injury cause, the defendant is to be liable for the injury. And to address the point that was raised by our friend, Ms. Torelli, in case of hypothetical scenario, we also raised in our factum that hypothetical events do not need to be proven on a balance of probabilities. Instead, they're given weight according to their likelihood. So as long as they constitute a substantial possibility. And the plaintiffs raised that that's the case at bar. There is a reoccurring a statement that was made by both our friends that Dr. Lenczner made an educated, evidence-based decision. And this is why our third argument for standard of care was so important. And it was that the standard of care itself was negligent. The literature that was drawn from Dr. Lenczner and his team was from a limited source that neglected something that an agency that he relies on, the FDA, provided to them. Another point that was raised was that there was no evidence of her improvement. And there actually was plenty of evidence that ivermectin is effective. And we can raise this based on Dr. Strange's account and in secondary sources. It's factually incorrect that during the time of treatment that there was no evidence that there was that ivermectin or proved to be ineffective. And on that note, there's no evidence at all that MAF Plus itself is an invalid treatment. And we'll raise something that is quite substantial on that note, which is that the hospital's COVID treatment plan is much more invasive than administering ivermectin and MAF Plus. At Dr. Lenczner's hospital, there was a code blue where the patient's sedation drug ran out, causing the patient to wake up and break the feeding tube, causing the food particles and toxin to escape from his lungs, resulting in aspiration, which led to infection. And the mechanical ventilation aspect of treating COVID patients in the hospital, intubating a patient is invasive, especially in patients in the ICU. And this is opposed to treating COVID-19 patients with ivermectin. Dr. Strange claimed on paragraph 31 of her discovery to have treated thousands of patients with ivermectin and have yet to witness a single side effect. Dr. Titchener claims in paragraph 76 of his discovery that not a single patient suffered death or injury when treated with ivermectin. And in case of the research that was done, there are 30 RTCs, 6,368 patients, 64 studies with 66% improvement with ivermectin. But with remdesivir, there's one study of 1,779 patients with only 17% improvement that was stated by the WHO. And also our secondary source, which we referenced, the FLCCC, also claimed similar statements regarding the efficacy of ivermectin and the dangers of remdesivir. And so it is the case that a reasonable physician would administer the safest, most reliable treatment to the patient at hand. But the standard of care itself suggests something that is more invasive poses a higher risk and a lower rate of success than ivermectin and math plus. And that concludes our rebuttal. Thank you, Justices.
This concludes the matter of Stark and Lutsier.